Hi, everybody, and welcome. It's Leslie with the New Mexico Small Business Development Center, and I'm here with Eden Alden, practicing attorney here in New Mexico. And we have a lot of his videos up on YouTube, but I want you to catch him because Ian always gives us such great information. I want to tell everyone before we get started that the New Mexico Small Business Development Center is strongly encouraging all New Mexico small businesses to learn about cybersecurity risk and make sure they are taking actions to protect their data, especially from ransomware. We have 3 cybersecurity webinars that have just been added to our website. These are no-cost webinars, and we encourage everyone to register for them. On June 16th, we have cybersecurity, outmaneuver cyber criminals with Mr. Larry Donahue. On June 23rd, we have top 10 mistakes hackers want you to make with Eric Spellman. And on June 29th, we have cybersecurity basics for small businesses with Steffi Rollins. Thank you, and I'll turn it over to Ian for understanding and avoiding breach of contract.
Thanks, Leslie. Hi, everyone. It's good to be with you for another workshop today. We're going to be talking about understanding and avoiding breaches of contract. As Leslie mentioned, we've got a lot of great workshops coming up. We'll give you a bit of a reminder, but first I want to point you to some resources that we've got available, some links in these slides, which you should be able to obtain. Links to resources for how to maintain a COVID-safe workplace is very important, especially now that everything is opening back up again, that you take the time to really maintain a COVID-safe workplace for your employees, for your customers and clients. It's one of the ways that we can all safely open up our economy together. So please make sure to avail yourselves of the resources at your disposal. A few notes before we get started. Your microphone should already be muted, but on the off chance that they're not or they come unmuted, please make sure that they stay muted. Make sure that your Zoom ratio is set to fit window. That's so you can see all of the slides. Again, it should be fit window by default, but if it's not, make sure it is. We'll be using the Q&A function to take questions. And I'm going to be taking questions throughout this presentation, so please feel free to ask your questions at any time. If maybe you misunderstood something, you want me to repeat it, or maybe you've got your own hypothetical you want me to look into an answer, please feel free to ask those questions at any time, but please ask them in the Q&A. I'm not going to be monitoring the chat window, but I will be monitoring Q&A. Additionally, you can raise your hand at any time and ask to just speak and ask your question that way. More than happy to take your questions that way as well. If you decide to save your questions to the very end, please write down your question and the slide number it relates to. You can see the slide number on the bottom right-hand corner of the screen. That way we can refer back to it as we need to. So as Leslie mentioned, we've got a lot of great workshops coming up. There's the one she mentioned that have just been recently added. We've also got a lot of others coming up, paid one on paid advertising on Facebook, intellectual property pirates, which is, who doesn't love pirates? Is your digital presence illegal? Probably. Basic steps to starting a business in New Mexico. There's a lot of great no cost to you workshops and other resources being provided by the SBDC. So please be sure to visit their website at nmsbdc.org. You can request no cost business counseling and loan application assistance, among their other great resources. So be sure to check that out. So we're going to be looking at, this presentation is going to be split into 5 mini parts. We're going to look at the basics of contracts and what they involve and entail. Then we'll move on to sort of fundamental breaches and what that means and how you can avoid those. We're going to look at some commonly litigated parts of contracts that we see breaches of, confidential information, intellectual property, restrictive covenants. That's a huge one that we see a lot. And then finally, we're going to talk about representations and warranties, which is huge for things like purchase agreements, business-to-business contracts. So we're going to be running the gamut here with different types of contracts. And I've got some examples that I'm going to show you, whether that's employment agreements, purchase agreements, leases, commercial leases. That's another huge one here. So we're just going to go over really what goes into a contract, what leads to a breach, and how you can avoid those breaches. So a quick little disclaimer here. The workshop is going to focus on breaches of written contracts and how to avoid them. There are verbal and oral contracts. They do exist. They're not a myth, but they lack the formal terms that we're really going to cover here. When we talk breaches of contract, we're talking about specific language, breach of a restrictive covenant or an obligation to pay or do this and that. You can certainly breach a verbal or oral contract, but they're very much a matter of he said, she said, they said. And so avoiding a breach of a verbal contract is a little bit like navigating a minefield with your eyes closed. So this workshop is going to focus on written contracts, which is fine because, looking at contract maxims, rules for good contracts, rule number 1, good agreements are made in writing. Good contracts are written. And that is so that everyone is clear on what they're agreeing to do, what they're going to get, and how their performance is going to be governed, what the rules are. Contracts provide rules and structure and guidelines. Oral agreements do none of that. You can't memorialize, you can't possibly hope to memorialize everything that you really want to agree on verbally. Even if you were to record it with a microphone and save the audio recording, you're still not going to get the same level of quality as you'd get in a written contract that everyone can read and revise and then sign. So good contracts are in writing. And that's kind of the first rule. And again, we talked a little bit about how easy it is to breach a verbal contract, especially if you don't really know what it is you're agreeing to, or if the parties can't quite remember. To avoid a good breach, a basic breach of contract, make sure it's in writing first and foremost. Contracts should provide clear and unambiguous expectations. The obligations of both parties should be spelled out and limited to what's contained in the contract. If you were in the workshop I led about employment agreements, you've already seen some of this because this is true of employment agreements and all other contracts. The contract should be large enough and detailed enough to make sure that everyone understands what's expected of them. Because if the parties don't understand what's expected of them, then breaches are that much easier. And then lastly, contracts should be predictable and enforceable. The parties should know what will happen if they or the other party violates the contract. If they breach the contract, you want to know what the consequences are going to be so that you can A, know whether to breach the contract or not, but B, know how to avoid breaching that contract. So these are just some simple rules of contracts that I hope if there's no other takeaway from this, take that away, because when you're dealing with employees, independent contractors, vendors, landlords, tenants, other businesses, partners, etc., the bedrock of good contracts are found in this slide. Now, this is about breaches of contract. And so we have to ask, what is a breach? And a lot of folks tend to conflate this term breach with default. Some people use it interchangeably, even though you really shouldn't, because they're not the same thing. At its core, a breach of contract is simply a failure to abide by one or more terms of the contract. If the contract says you're supposed to do this and you don't do it, that's a breach. If the contract says you're not supposed to do this and you do it, that's a breach. But it's not always the same as a default. A default is more an inexcusable breach, a breach that leads to usually automatic consequences, or at least the right of the other party to impose those consequences. And a common example is found in leases. Most leases are going to provide for what's called a cure period, where if you don't pay your rent when it's due, and then you fail to make the payment within 15 days thereafter, that's a default. And you look at that scenario, the failure to pay when due was a breach automatically. When that payment's due, if you don't make it, if you haven't made it by that point, that's a breach of the contract. Not really all that ambiguous, it's just a breach. But the default doesn't occur in this example until you've waited out the cure period, which is 15 days. So if you don't make the payment within 15 days after its due date, you're in default. Why does that matter? Because most consequences in contracts come after a default, not simply a breach. Now, there are cases where the breach itself causes damages, and in those sorts of situations, you might be looking at a lawsuit over those damages of breach. But a lot of contracts, and the leases are a common example, don't have consequences that really trigger until after a default. Now, you look at breaches and you might ask, okay, let's say I breach this contract, or let's say someone else breaches their contract with me. What are the consequences of that breach? And most of the consequences are spelled out in the contract, but some consequences just exist as a matter of law, whether that's statutory law or the case law that's come about over the last few hundred years. There's different remedies for the wronged party to pursue. The first and most common that you see is monetary damages. You breached this contract, it has harmed me to the tune of X number of dollars, I demand that money. Monetary damages can also include, in some cases, court costs, attorney's fees, speculative damages, consequential damages. You harm my business and cost me X number of dollars in potential profit over the next few years, so I want that as well. Monetary damages can take a number of different forms. There's punitive damages, which are, as they sound, meant to punish the other party. You see punitive damages in cases of egregious conduct. If someone does something that's willful or wanton that harms another party, there might be punitive damages at play. The other, another common form of relief in breach of contract cases is called estoppel or other injunctive relief. Basically, the court is going to say, you need to immediately stop doing this. A common example of that is in breaches of non-competes. The court might order the breaching party to stop their competitive activities. If someone takes your intellectual property and tries to sell it to the highest bidder and you catch them in time and whatnot, you could get injunctive relief against the person trying to sell your intellectual property, or maybe against the person buying the intellectual property. At its core, it really is just the court saying, stop that. You might also get a court order for what's called specific performance. This is where someone doesn't do the thing that they say. And the only remedy that would make the other party really whole is for the breaching party to do the thing they said they'd do. That is called specific performance. It is very rare that the court will order specific performance, very rare. You see it a lot in real estate contracts, agreements to sell something or buy something, provisions for specific performance that the courts will occasionally enforce. For example, let's say you have entered into an agreement to buy a house for $200,000. And the contract provides that in the event of a breach, the other party is entitled to specific performance. And then the market skyrockets between the point when the agreement is reached and the point when closing happens. And then the selling party decides, you know what, I could sell my house for $250,000 to this guy, so I'm just going to walk away from this contract. Monetary damages might be $200,000. It might be nothing because there's technically no monetary harm to the other party. But in the interest of fairness and equity, the court might look at that and say, you know what? A deal's a deal, and we're going to make you sell this house for the price you agreed on, even though it's now worth more. We're not going to let you benefit by walking away from the contract, so you have to sell this house. That's specific performance in a nutshell. And then other relief that's specifically provided for in the contract. This, this would typically include all the things we've already talked about. Injunctive relief, monetary damages, specific performance. That's usually written into most contracts, depending on the type of contract, but there could be other relief as well. A common example is what's called liquidated damages. Basically, the contract is saying, if you breach this contract, it's going to be impossible for us to reasonably calculate the damages. So you're just going to agree contractually to pay us $100,000 as an example, if you breach. Liquidated damages are basically the contract saying upfront what the consequences are going to be if there's a breach, without having to figure out what the damages might be. You can combine all of these things or some of these things. They're not mutually exclusive. For the most part, sometimes liquidated damages will preclude other monetary damages, but these are some of the different consequences you can expect to see in a breach of contract case. Some other remedies you might see, and this is very specific to leases, commercial leases especially, is a payout of the remaining term of the lease. Like, let's say the tenant walks away 1 year into a 5-year lease. The lease might provide that the tenant, despite walking away, is on the hook for the remaining 4 years, less whatever amount the landlord can get from reletting the property to some other tenant. The landlord would have an obligation to what's called mitigate their damages, which means, do what you can to reduce your damages. Parties have that obligation to mitigate their damages so that they don't just sit on them, let those damages snowball, and then go after the breaching party. The courts don't like that, juries don't like that, judges don't like that. So there is an obligation to mitigate your damages, but then once you've mitigated, leases, for example, have this provision where landlords can go after the tenant for the remaining balance. It's called a deficiency balance. You see the same thing with mortgages. If the property is foreclosed on, it can be resold, and then the borrower is on the hook for the remaining balance of the mortgage and note, which is the deficiency balance. So these are some remedies, some damages you can expect to see in contract and breach of contract cases. And it's important to understand that because there's this thing called strategic breach. Sometimes you're in a bad contract and you want out, and you know it's a breach, but you also know that the consequences based on what's written in the contract are going to be so minor that it's more advantageous for you to breach the contract than to fulfill it. That's a strategic breach, and it does happen. There have been some cases where, I try not to advise my clients to breach a contract because there are problems, there are damages, there are consequences that will ensue. But I do tell my clients that it might be more beneficial for you to breach. So just things to keep in mind as we go forward looking at the different contract scenarios. Now, when we talk about fundamental breaches, we really want to look at what goes into a contract. Functionally, contracts are promises two or more parties make to one another. Party one promises to provide services or do something. Party two promises to pay for those services. It's a super basic contract, but you can balloon contracts out in all kinds of different directions, add multiple parties, add mutual obligations, etc. But at their core, it's just two or more parties agreeing to do stuff. Nice and simple, right? So when you look at a fundamental breach of a contract, we're talking about a breach of those terms: who, what, where, when, and why. The why doesn't matter so much. You can't breach a why, but we're talking about breaching kind of the basic terms of the contract. So, for example, who, and you might think that this is something you can't breach a who, because the contract provides, contract between party A and party B. Nice and simple, right? What if you're dealing with a person who owns multiple businesses and you contract with business A, and then business B ends up performing under that contract. That's actually a violation of this term of the contract because maybe you didn't want to do business with business B. Maybe business B has some problematic elements to it, some creditor issues, something like that. Certainly in sale agreements, you want to know who you're dealing with and the parties matter. So, I've seen where people try and perform with different parties than those who contracted, and it creates issues because, among other things, maybe a company B couldn't really assume legally the responsibilities under the contract for one reason or another. Maybe the contract itself forbids assignment or assumption without permission of the other party. Most of the contracts I write do prohibit that, and so that's an automatic breach right there. The what? This is the most common breach. I mean, again, at its core, a contract is an agreement between parties to do things for each other, provide services, pay money. So one party fails to provide those services, one party fails to pay the money. That's the most common breach of contract you'll ever see. And so this is, when we talk about avoiding breaches, the best way to avoid a breach of this part of the contract is simply to know what you're agreeing to do. Read the contract, read it again. If you're not sure, consult with the lawyer or other professional to interpret it and make sure that you understand what it is you're agreeing to. Because even if it's an inadvertent breach, even if you don't mean to breach the contract, a breach is a breach. And so you don't want to find yourself in the position of not doing something that you agreed to do because you didn't know you agreed to do it. So, like I said, the what is the most commonly breached part of any contract. Here's an example here for a commercial lessee to pay to the lessor, to the landlord, some huge amount of money over a period of 10 years. Here's another example in an employment agreement. Employer is engaging employee to provide these services, employee is agreeing to provide them. You list out the services and whatnot, but end of the day, this is a basic example of what employee is agreeing to provide these services. If employee doesn't do it, it's a breach of the contract. Similarly, the employer is agreeing to pay the employee. If the employer doesn't pay the employee what they're owed, I mean, you're going to run into DOL issues, FLSA issues, wage law issues, etc. But you're also looking at a breach of contract claim in the event that there's a written employment agreement or even a verbal employment agreement. I mean, it's an agreement to pay the employee. So things like that, the what, it's very common to see breaches of this. The where, it's less common to see a breach of this, but it happens, and it happens kind of frequently in construction matters. I found whether there's confusion about where the services will be provided, or there's just a fundamental misunderstanding there. Here's an example. The employee is going to provide services at the employer's principal place of business. This isn't remote work, just at the principal place of business. Failure of the employee to show up for 45 hours a week during these hours at the employer's place of business is going to be a breach of the contract. So the where, the when, they're less common, breaches of them are less common than the what, but it does happen. So things to keep in mind there. Again, you can't really breach a why because the court doesn't care so much about the why. If the parties are performing under the contract for reasons other than why they initially entered into the contract, who cares? They're performing under the contract, so it's not really a breach scenario. But another very common breach of the contract, and this is fundamental in my opinion to the contract, is termination. Pretty much every contract, I mean, they ultimately have to say when the contract ends, whether that's through termination by one party or the other, or both parties for convenience or for cause, or expiration or conclusion. Maybe you've got a contract for a term of years. The contract has to end at some point, or at least provide the parties the means to end it. If we're talking a commitment that cannot ever be ended, that contract's probably not going to be enforceable. Even leases that are considered indefinite or permanent leases are really leases for a term of years. You see this frequently, 99-year leases for things like that. They're never truly permanent. So yeah, keep in mind about termination, regardless of how or whether you terminate it. Termination typically does not excuse a breach of contract. There's a typo, breach of contract. Termination does not excuse breach of contract unless the contract specifically says termination will relieve the parties of all obligations to one another. That's exceedingly rare in a contract. And so even if you choose to walk away from the contract, if you've already breached it and caused damages to the other party, you could still be looking at claims. And similarly, and this is very common, there's this thing called wrongful termination, which basically means you've ended the contract in a way that you were not allowed to do. For example, if the contract provides you can only end it for cause or with a certain number of days or months of notice, and you just walk away saying, I'm out for convenience, that's wrongful termination. And that in and of itself is a breach of the contract. So it's important to understand before you sign a contract, how can I end this contract? How can I walk away from this contract? Can I walk away from this contract? When will this contract end? It's so important to understand where the doors are, that so that if you need to, you can make your way to the door in a contract. So that's a note on termination there. Here's an example of a termination clause for a lease I wrote. And specifically termination in the event a party defaults. You know, lessees typically have very little recourse in a commercial lease, especially with power dynamics being what they are. Commercial landlords have a lot of the power in drafting these contracts, but in this one, I threw in a provision for lessor default, where if the landlord defaults, if they don't do what they say they're going to do, maybe it's repairs to the property or otherwise, and they don't cure after being given reasonable notice by the tenant can choose to end the lease. That's what's called a termination for cause. And so here's an example of how termination can work. But if the tenant just throws their hands up and says, I'm out, they walk away without following any of this, even in the event of a lessor's breach, if they don't follow the terms set out here, that's wrongful termination. And that in and of itself is a breach of the contract. So next, we're going to look at some more nuts and bolts parts of the contract. And this may or may not apply to everyone, though you would be surprised. It probably applies to you. We're going to look at confidential information, intellectual property provisions, because those are some commonly breached provisions of independent contractor agreements and business-to-business agreements where intellectual property is being shared or contributed to. And, you know, breaches of these agreements can create huge damages for companies. They could sink a company because if your intellectual property, your proprietary trade secrets or whatnot leak and are then duplicated and replicated and resold by a competitor who doesn't have to spend the money on development that you did, you know, you might never recover from that. So it's important to understand what these provisions are, what breaches look like, and what you can do about it. So, you know, basics of this, you see this a lot with employees, independent contractors, or vendors. They're going to be in a position to learn your trade secrets. You see this also in certain business-to-business arrangements where you've got co-development or manufacturing or production agreements. Maybe you've developed something and you're hiring another company to manufacture it for you or to ship it for you. They're going to have access to your trade secrets, your intellectual property, your designs, things that you've patented. I mean, they're going to have a lot of access. And with that access comes the potential to really you know, run amok with your property for their own proprietary or pecuniary gain. I mean, they can really, like I said, do some underhanded things that could ruin your business. So you look at what a trade secret is, for example. You've got all of these things here and more. Trade secret is just, you know, kind of anything that doesn't fall into copyrights or patents or whatnot or trademarks, but that are unique and proprietary to you or your business, and that you take reasonable measures to keep secret. Trade secrets, there's typically provisions in contracts that, at least the ones that I write, that say the trade secrets remain the confidential information and property of your business, your company. You cannot do these things with trade secrets. They have to be kept secret and returned to you upon termination of the contract. That's a very common provision in the contracts I write. Again, they might also have access to your intellectual property more broadly. You talk about your software or website code bases, marketing materials, etc. They're gonna have a lot of access. The other part of this is that they're also very likely to contribute to the creation of your intellectual property. Some examples are software developers who are working on your website, content editors creating content for you, mechanical engineers creating new designs, new processes, things like that. I mean, when you hire people to help you build your product, they're contributing to that product. And so there becomes questions under the law about who owns the intellectual property that they're contributing to. Absent good provisions in your contract, they might have a claim of ownership, a shared claim of ownership, where you might end up in a de facto partnership with them despite you having no intention of sharing this IP or any business with them. So it's important to have good contract provisions. We're going to look at a few here that provide that your intellectual property is yours. Your trade secrets are yours. Your patents, your trademarks, etc., your copyrights, they're yours. And any work that they do on that is work made for hire. So like I said, good contracts are going to provide these things. Restrict access, restrict use, and provide that the intellectual property is at the end of the day yours, that any ownership of it vests in you, transfers to you. To the extent it can't, for whatever reason under the law, you get an irrevocable worldwide exclusive license to use it. Basically a step just shy of owning it. So the contract should provide these things. And when the contract provides these things, we get into the potential territory of breaches of contract. What happens when the other party agrees to these things and then doesn't follow through with their obligations? Here's an example of the contract provision regarding confidential information. They're basically agreeing as the employee that the employer's confidential information is the employer's property, and they're not going to use it or disclose it. So what happens if they do? That's a clear breach of contract right there. If the employee turns around and makes use of the confidential information for their own purposes or tries to sell it to a competing entity, etc., that's a breach of contract. What can you as the employer do in that situation? You can send a cease and desist letter, a demand letter. Maybe that makes them back off. If they don't back off, maybe you sue. And when you sue, you're going to ask the court for two things: monetary damages and injunctive relief, basically asking the court to make this employee stop doing the things that they're doing that are breaching this agreement, making sure that the court orders them to stop trying to make use of the confidential information, stop trying to disclose or sell the confidential information, stuff like that. So you're going to ask for those things from the court. Typically, when you're dealing with these sorts of matters, the courts are often going to grant that relief because it's in the contract. It's fair and equitable to the employer to protect their proprietary interests. So the courts will grant that. And that's what happens in breach of contract case here, over your intellectual property and confidential information. And this is why, again, I'm kind of harping on this a lot, but it's so important to have these things in a contract. Because if you don't have them in a contract and the employee goes off and does these underhanded things, is it a breach of contract? Probably not, because it wasn't in the contract that they couldn't. You might have claims of, unjust enrichment, things arising under the law, but they're a lot harder to prove than, showing that the employee agreed to do this thing and then they didn't do it, or the employee agreed not to do this thing and then they did it. Having it spelled out in writing in a contract is so important, and that is how you get these breach of contract claims in the first place. Another common example here is work for hire. And this one can get complicated when you're talking about breaches of contract, because work for hire or work made for hire, when you hire someone to contribute to your intellectual property, like I said, the mechanical engineer who's contributing to your designs that you're ultimately going to put into manufacturing and sale, they are contributing to your intellectual property, and they're agreeing that it's work made for hire and that the intellectual property is ultimately yours. What if they turn around and say, no, I don't care about any of what I agreed to. This is mine. I'm going to demand a cut of it. That's a breach of contract right here. And in that case, you might look to the courts for what's called declarative judgment. That's basically the court saying in advance of there being any real dispute, or at least any real damages, you ask the court to say, we have looked at this contract, we have looked at the employee's position and the employer's position, and we have decided that yes, this contract is binding and this intellectual property belongs to the employer as per the terms of the contract. That kind of closes off any potential for the employee to turn around and lay claim to the IP. I mean, they still could, but they'd be violating both the contract and the court's judgment at that point, which is a bad look for anyone. Or maybe you're in a situation where they've agreed to this and they've already run off and struck a deal to sell their interest in this intellectual property to a third-party company. Then you're looking at a lawsuit with that employee and possibly the buyer of the intellectual property, where you get the court to decide that based on this contract, that IP was never the employee's to sell. So it doesn't belong to the employee or to that buyer. It belongs to you, the original employer. These are things that can happen in breach of contract cases arising from work made for hire provisions. But again, going to harp on this all session long, it's very important to have this stuff in writing, because if you didn't have this in writing, maybe under common law that employee does have a claim of ownership to the intellectual property, in which case they can turn around and sell their interest, and then you're dealing with a business partner you had no intention of partnering with. So fun stuff, but the TLDR, the short of it is you can look to the courts for relief under these contracts. So, we've talked about some of the different potentials for breaches of contract for these provisions, and we've talked about some of the remedies, what that looks like. The most common, again, is injunctive relief, asking the court to order the parties to stop doing what they're doing. Incredibly common, and it's incredibly common if you get in early enough. You don't want to sit on a breach of contract claim, especially when it relates to your own intellectual property. The law requires you to be diligent in protecting your interests. If you're not diligent in protecting your trademarks, for example, you can lose those trademarks, or at least lose the ability to enforce them. So, be diligent, be active, and know what your rights are under the contract and what your remedies are. Restrictive covenants are the next one we're going to talk about, which is basically non-competes, non-solicitation agreements, non-disparagement agreements. The technical definition of a restrictive covenant is basically a covenant that prohibits another party from doing something. It restricts that party. These are the three most common of them: non-compete, non-solicitation, and non-disparagement. So we're going to look at them. Non-competes are, an agreement not to compete. They're very difficult to enforce in the state and in many other states, but in this state in particular, public policy really disfavors their use with employees, and the New Mexico law bans them outright with respect to certain healthcare practitioners. You can try and use them against independent contractors or vendors or businesses in a B2B relationship. Frankly, it's a bit of a crapshoot as to whether or not you can enforce them, because to be enforceable, they need to be reasonable. They need to be geographically and temporally limited, meaning a set boundary in which the party cannot compete, and a time limit for how long they can't compete. and they need to protect a legitimate interest of the party looking to enforce them. And that's the kicker for independent contractors and B2B relationships, because especially with independent contractors, the law considers them to be their own business owners. So having them agree not to compete with you, it can be pretty tricky to enforce them. So I'm just saying that up front. Here's an example of a non-compete. It's pretty straightforward. 12 months, geographically limited to the counties in which an employer does or did conduct business during the term of employment. It's reasonably limited. I've seen the courts enforce contracts, non-competes with these limitations frequently, but then the court still looks at the interests of the employer, the proprietary interests of the employer that might be harmed if the non-compete is not enforced. And I use this example a lot with non-competes. I don't mean to pick on them, but frankly, they kind of had it coming. There's a sandwich shop that I'm actually looking at from my window. Not going to name them, but they used non-competes against their employees pretty aggressively across the country, who all they did was show up and make sandwiches. And they had these broad non-competes against the employees that they tried to enforce against the employees to prevent them from working for competing restaurants. And those employees tended to have very limited skill sets. They didn't have a lot of education. And so the courts looked at this and said, you, big multinational sandwich shop, have no proprietary interest that's going to be harmed from enforcing non-competes against these employees who are trying to make a minimum wage living slinging burgers at this burger joint or making sandwiches at this other sandwich shop. Nothing that you do is going to be substantially harmed by this. And so the non-competes kept getting thrown out, and it was just a black eye for them. So I think they stopped using those non-competes at some point, but the point is, this is one of those breach of contract scenarios where despite the breach, you might not actually have a remedy. And so I try and explain this to my clients who are employers especially, but just because you have a contract and you have a breach, that doesn't mean you're going to get something out of it. So it's important in these situations to understand that. Similarly, you've got non-solicitation agreements. These are a bit different. People conflate the two, but they're very different. Non-competes mean you can't compete with the business in a very broad sense, just can't compete. Non-solicitation means you cannot poach. So you can't poach employees, you can't poach customers. For example, it's very common when you're dealing with situations where one party has the customer list of the other, or in B2B arrangements or joint ventures where one party could take the employees, the key talent from the other party, and then force them out of the joint venture and then just put them out of business because of the size disparity, the power disparity. Non-solicitation agreements have a lot of very important uses, both with employees, independent contractors, but especially in B2B, business-to-business arrangements. And so breaches of these, you might be looking at injunctive relief and monetary damages, especially if they're poaching clients. You look at what you expected to get from those clients or customers, and you can reasonably figure out what your monetary damages are. And so non-solicitation agreements are very important. And even if you're not going to put a non-compete in, a non-solicitation agreement is a good idea in the vast majority of contract cases. So that's something to keep in mind there. Breaches of those can have real consequences monetarily and otherwise. Here's a simple example of that. They're agreeing not to solicit anyone who's an employee of the employer, who is or was. One key thing to keep in mind with non-solicitation agreements, you cannot, it's a fine line between them and non-competes, but you cannot cross that line to where you're treating competition as a breach of this non-solicitation agreement. They're not the same thing. You also can't use them to prevent employees from going to work for, that, let's say you have an employee who signed this, then they go off and start another business, whether it's competing or otherwise, and they've got this non-solicitation agreement that says they're not going to poach your employees, they're not going to solicit them to leave your employment to go work for them. Fine, but if you have other employees who really liked that one employee and say, oh, I see he went off to start his own business, I am of my own accord going to go work for him. Is that a breach of this non-solicitation agreement? No. No, it is not. And so the same is true with customers. When courts look at that situation, it's not a breach. Sometimes folks work in, you cannot employ anyone who's an employee of mine, or you cannot service anyone who is a customer of mine. That treads into very murky waters where courts are very reluctant to enforce. They don't want to enforce, prohibit an employee from working for someone because of a relationship between, or an agreement between that someone and someone else. I mean, the courts don't want to wade into that. They especially don't want to wade into it with respect to customers. And I litigated this a few years ago with an insurance salesman who was captive to one insurance carrier and then went off to start his own shop. And his customers, when he worked for that carrier, really liked him. It's very personable. And they, of their own accord, reached out to him to switch their insurance over. The court said that the agreement between the carrier and that insurance salesman that said the carrier, the salesman, if he goes off and starts his own thing, cannot provide services to any customers of the carrier, that was unenforceable because it unduly restricted the general public from choosing who to do business with. And so a good rule of thumb here is if you're trying to restrict the business choices of the general public through your contract with another party, the courts are probably not going to enforce it. Maybe they do. They might if you have liquidated damages provisions in there, but on the whole, courts don't like it. So that's another breach of contract scenario where you might not have a remedy. Finally, non-disparagement agreements. This is pretty straightforward, but also pretty vague. Don't make disparaging remarks to third parties that might reasonably expect it to result in reputational harm. So saying, this can get into some weird, vague, murky territory itself, because if I go to, if I worked for employer A, and then I leave their employ and I go say to my friend, I really didn't like them. Is that disparagement? Probably not. Could it be? Maybe. If by saying I don't like them, you have prevented that, I prevented my friend from doing business with them or going to work for them. I have damaged their reputation, at least in the eyes of my friend. Is that disparagement? Probably, maybe, could be. And so these are actually really easy to run afoul of. And so if you have a non-disparagement agreement, it's good to at least set some boundaries for what is or isn't disparagement. Here's an example of a non-disparagement clause that is broad, and it was made broad at the insistence of the employer. I don't like it because, again, it's broad. It leaves a lot up to someone's subjective determination of what is or is not disparagement. But is it enforceable? Maybe. Because it's so broad, the court might look at this and say, we cannot reasonably justifiably hold another party responsible for this disparagement, so we're not going to. Maybe they do, in which case you're gonna have to figure out what the damages are of that disparagement. What did it really cost you as the employer? Nothing? Then why did you sue? You might be able to get the court to order that the party stop disparaging, and that's more common if you've got an employee who leaves your employment and then goes out and torches you on Yelp and Angie's List or whatever replaced Angie's List, or et cetera, et cetera. If you've got a disgruntled ex-employee who's out there publicly and visibly disparaging you, you might get the courts to order some injunctive relief at that point. Or you might get the courts to say, okay, you're costing this company business. We're going to guesstimate that cost at about $100,000. It's a bit of a crapshoot when you're looking for monetary damages for non-disparagement. unless you can prove that it cost you a specific contract. If you had a contract or were in the process of negotiating a contract and it looked like a sure thing, and then the other party said, you know, I see that your ex-employee doesn't like you and they've been saying pretty bad things about you, so we're walking away, then you've got a pretty easy claim for monetary damages there. But otherwise, it's pretty difficult to figure out what the harms are when you violate a non-disparagement agreement. So some final considerations on restrictive covenants. They should come with 2 clauses, blue penciling and severability. Blue penciling allows courts to reform restrictive covenants if they're too broad. So let's say you said can't compete for 5 years. That's too broad, but a blue penciling clause will let the court say, okay, 5 years is too broad. We're going to make it 2 years, and it's still going to be enforceable. Without blue penciling clauses, the court, it's really unsettled law in New Mexico, but the courts will typically just toss the provision wholesale, saying, all right, it's too broad, it's completely unenforceable, we're just going to ignore it, it's gone. You also want to make sure your contract has a severability clause, because that allows the court to sever an unenforceable provision without voiding the entire darn contract. So without that, they could say, okay, your restrictive covenant is too broad, your entire employment agreement is invalid, just nixed, it's gone. So severability, I don't know that I've ever drafted a contract without severability. That's not true. I've drafted 1 or 2 where the parties insisted that there be no severability, but otherwise I throw it in pretty much every time as a matter of course. Because without those, your remedies in a breach might really backfire on you. If you try to enforce a restrictive covenant and the court throws out the entire contract, they also throw out the intellectual property protections, which means the employee can then run amok with your intellectual property. You might still have claims against them, but not breach of contract. So, you know, these little details really matter when you're talking about breaches of contract, what the remedies are, and what the risks are, even trying to enforce your contract. So that's just something to keep in mind. Finally, we're going to talk representations and warranties. And this is actually a surprisingly simple concept on its face. They're just things that a party represents and warrants are true. And here's a big old example. I deal with this all the time in my practice when I'm dealing with buying or selling a business. The seller is going to represent and warrant that they own the business. They're authorized to sell it. They haven't already agreed to sell it or, you know, pledged it, financed against it, et cetera, to any other third party. They haven't done any of that. They're in a position to sell it. They aren't going to be subject to any other breach of contract claim if they sell the business. That everything is true in these representations and warranties. And then, you know, some other common things are no outstanding tax debts or liabilities. Fairly straightforward there, but you know, if the company represents and warrants that there's no tax liability of the business, and then it turns out that there was a big old tax liability of the business, that really changes things, because a breach of the representations and warranties really means that the other party was misled into entering into the contract. And here's an example here. The buyer pays $1 million for the business. The business owes 200 grand in taxes, despite the seller saying it didn't owe anything. So the buyer, because the buyer becomes on the hook for those taxes, they're misled as to both the condition and value of the business. The condition being tax-free, the value being, you know, if they paid $1 million, but the business actually had a $200,000 debt, the business was owed, it was worth $200,000 less. And so when you see breaches of representations and warranties, the remedies get a little interesting, because it's not just monetary damages. I mean, it can be. You can just sue the seller for 200 grand plus your costs, et cetera. But you could also ask the court to invalidate the contract and restore the parties to the position they were in before the contract, meaning seller gets their business back, buyer gets their money back, probably with costs and attorney's fees because of the breaches of representations and warranties. You know, most contracts I write have indemnification provisions that mean, you know, if the seller breaches their representations and warranties, they need to cover the damages of buyer, including their costs and attorney's fees. So you know, it's very important when we're talking about avoiding breaches of contract. Please, please, please read your contracts. Read what's in the representations and warranties, because this is what you are promising and asserting is true. If there's something that's not true in there, you need to change it before you sign the contract. Because once the contract is signed, if something turns out to be false, especially if it's materially false, I mean, you know, if you represent and warrant that you're non-material breach. I mean, if you represent and warrant that, you know, I'm actually blanking on any examples of non-material breaches. Pretty much everything has the potential to become a material breach depending on the way it's discovered and the harm it has for the buyer. So, you know, if you have a breach of the representations and warranties, you're looking at all kinds of different damages, monetary and possibly rescission of the contract. So be very careful with that. What can I do to protect myself? Have good contracts. Know what's in the contracts you sign, and then plan ahead to meet your obligations instead of figuring out what your obligations are after you've already signed the contract or after you've already breached the contract. It's easier to avoid a breach by being proactive. If you're being reactive and you just sign the contract and then, you know, you wait for something bad to happen, that's already way too late. You've breached the contract. There's damages, there's money you're going to have to pay. You're probably going to have to pay a lawyer to figure out the situation if the other party hires a lawyer. These things can get expensive quick. Breaches of contracts, I mean, they're the bread and butter of our dispute resolution practice. I mean, they're almost entirely what our litigation team works on. I'm a transactional attorney. I write the contracts. I really don't deal too much with litigation or dispute resolution or enforcement anymore, but we've got an entire wing of our law firm that does that because of breaches of contract, because some party either didn't know what they were agreeing to or decided that they were going to roll the dice and breach the contract. So, yeah, know what's in the contract, know what you have to do. Last takeaway here, every business owner situation is unique to them. It's very important to work with knowledgeable professionals who can provide you with the advice and counsel that meets your needs, who can help you draft contracts that meet your needs, who can advise you on breaches of contract, whether that's your breach or the other party's breach. So the best advice I can give you here is know your resources and utilize them. Best thing you can do is reach out to your local SBDC, your Small Business Development Center liaison, or visit nmsbdc.org. Like I said, they offer no cost business counseling. They offer loan assistance. They offer workshops like this that are no cost to you. I mean, they offer a wealth of resources and they have a network of great resources. If they can't help you, they can point you in the right direction or kind of help you get where you need to go. So, like I said, be proactive, because it is so much easier to avoid a breach of contract than it is to deal with it after the fact. So use your resources. Does anyone have any questions? We haven't gotten any so far, but feel free to ask them in the Q&A or raise your hand. I'm going to look at the chat window now, but just let me know if you have any questions.
We don't have any questions that have come in right now, and I think the one, there was a couple things. Ian, first of all, when you said you couldn't even think of any breach of contract that wasn't defined like that, that slide that you were talking about tells everyone the importance of avoiding breach of contract, because I think it's easier sometimes to avoid it than get in at the end and try to pick up the pieces.
It's also a cautionary tale about not assuming that this provision of your contract doesn't matter, because even if you don't think it matters, it could matter to the other party, or they could use it as an excuse to trigger one of their remedies, whether that's termination of a contract or whether that is looking to you for monetary damages. Maybe the relationship is soured and they're playing look for a reason to get out of the contract. So even a minor breach can create huge consequences.
I think that's an important point because they may be looking for a reason, like you said, to get out of the contract. And so again, like we always recommend, protect yourself and your business. So
Yeah.
do you have any last words before we wrap up today?
Like I said, just use your resources. I see this all the time with clients who have had so many resources within reach and at their disposal, and they didn't make use of any when it could have helped them more. So be proactive, use your resources, reach out to the SBDC. Like I said, there's a lot of great opportunities for you to learn and grow your business and deal with a lot of these issues before they really become issues.
Awesome. Thanks as always, Ian, for giving us great information, and check out nmsbdc.org for any of your no-cost business counseling needs. And you guys have a great day. See you next time.
Thank you all.